Hi friends from around the world, this is a bonus session. I wanted to present you something on trade secrets, but this is too early with regard to case law, important case law, which I can share with you. You know that the Copyright Directive has been adopted in 2016, and there are 2-3 years in order to transpose the minimum requirements, what is required by the Trademark Directive, into national law of the 27 member states. Now, Germany, for example, they have transposed the requirements of the Trade Secrets Directive in 2019 only, and the other countries as well. So some are always a bit behind. Now, with regard to the deadlines or the timing, you have to reconsider the judicial timeline. So there are no really timeline for judicial, judgments, right? So you need to, and we have seen judgments. We have seen cases where it took 10 years in order to come to a final decision. So here it is too early. We are not at the point of expecting a judicial decision from the General Court or from the European Court of Justice within a short time. So once I will get to that, I will grab on something which is important, something which is relevant for you with regard to trade secrets. I will put this here on the channel. So if it is not too early to go into case law, but what we know is clear. You know what a trade secret is, and you know how to advise your client with regard to trade secrets as such. So the trade secrets is nothing which can be registered in principle, right? There are some initiatives to make it registrable, but it is not at the point to go mainstream. And what is a trade secret? Well, is a commercially valuable information. It can be any kind of information. It can be precisely what it can be is a customer list, a design of a plant, a taste, how to compose a taste, or a color, a new, it can be a new chemical component, or it can be everything. You know, the Listerine case or the Coca-Cola, well, it can be anything. But it must be commercially valuable, right? If it is not valuable, why would you keep it secret, or why would you put much effort into it to keep it secret? So it must be commercially valuable. It must be secret, so it must not be known to everybody. Well, that's clear. And finally, there must be reasonable measures in place to keep it secret. So that is up to you now. Up to you to advise your client, and up to the client to implement your advices with regard to the trade secrets they want to protect it in that manner. Now, I'm interested, for example, in judgments which would, that in the Enforcement Directive you have the possibility of an injunction in order to get a bit more details and in order to formulate your damages more concretely. So you need, for example, the infringing customers in order and what have been, sold or used or downloaded or whatever it is. And then you can specify your damages, and perhaps you want even to have the addresses of the different users in order to claim against them. And that is only the defendant who has that information. So the Enforcement Directive gives you the possibility to claim to the defendant that the defendant provide the necessary information to the court, which is then shared with you. Now, if it is a customer list, for example, which is protected by trade secret of the defendant, how can this be managed? Trade secret on one hand, and injunction and the right for information of the, so to say, the claimant, of the one who have suffered losses. So how does that fit one to the other? This is one kind. So another kind is, what is reasonable protection? Reasonable protection, well, that's another issue. It is not specified in Europe, so there are some case laws which come up one after the other in the future, and we will see how the court would assess what is reasonable and what is, well, unreasonable to require from the trade secret owner to have implemented into its company in order to keep something secret. But I want to go through some, so to say, common sense issues which you can advise your client in order to be on the safe side. If your client wants to use the protection of trade secrets in its business, rather than going for, I don't know, for invention or for design, well, it may be at least complementary. So trade secrets is not something which you need to be in the abstract and as the only protection. You will have also other protections around, so that if trade secrets goes into the open for whatever reason, you have still other possibilities which need to go in that sense. So precisely one of the main things I would always recommend with regard to trade secrets is to make in the beginning to rely heavily on the trade secret, but reverse engineering, or it may come from another source. Somebody invent the same thing. Now, in the beginning, it is a trade secret, and you have it as a trade secret, and you have the product with the incorporated, so to say, the trade secret, but then you want to market through trademarks, and you get the product attached to the trademark. You have it protected also through trade secrets so that others cannot do it. But over time, maybe the trade secret will be lost, or it goes into the open, and then you would have nothing if it would not for the trademark, for example. So the trust between the product and the consumer is already, after some years, will be then linked through the trademark. And even if the trade secret goes into the open, then afterwards, well, it does not make any harm. Now, what are the measures you should advise your clients with regard to what has to be done in order to be sure in court to not to be caught? So the first thing would be rules, procedures, and records. So you must have rules, and it must be written. So must be evidence. There must be some documentation which you lay down as the basic rules. What is the company policy with regard to that trade secret or the other trade secret, or what is the procedures put in place, and since when, and what is the trade secret? Probably as well. You put it somewhere on paper, and to have the documentation ready that this is something that's yours. Now, the policies, the procedures, and the records, there must be documentation, which in case you may need to provide to the court, for example. Now, security, confidentiality management, that is another issue. You need to have in place now the procedures with regard to the people who has access to what, and it must be on a need to know basis, not that everybody can have access to anything. So there must be some non-disclosure agreement to be signed by those who have access, or who have access with regard to the trade secret, and it must be also clear that once they cease to be in the office, they cannot disclose for a certain time the trade secret, or can never disclose the trade secret in order to. So this is an important issue with regard to the people, because the normally 90% of the trade secrets infringement come from employees, come from those, not from spying of other companies, but from internal employees who have a certain access granted to the trade secret, who know the trade secret, and at a certain moment, so it works well when it works well, but when the contractual relations went sour, went south, and the promotion is not in when it should be in according to the employee, then there is some problems, or is looking for another, or gets an offer from another other company who is interested also in the trade secrets, or the competitor of yours, then it may go into the open, and then the problem starts. So the employees are one of the main sources of trade secrets infringement. Risk management is also an issue. So the company need to make an assessment on what is the probability of the trade secret to go into the open, and what is the damage which can be inflicted on the company. So depending on that risk management, you should make more investment into the protection of the trade secret. So if, so to say, the company is wiped out without that trade secret, then this is a vital thing, a very important thing, and you should better focus a bit at the maximum to this trade secret. That is what is your core business, right? So you need to protect your core business. Then information protection team. So you would need somehow a leader, a kind of leader with regard to the project of the trade secrets protection, and a team which is, well, an audit, if you want, or a team which is dealing with it constantly in order to get a follow-up, follow-through, and to make new appointments, to see that the non-disclosure agreements are signed, if a new assignment has to be done, and the access grants, so physical or IT access, which has to be managed, etc. So that must be done by the protection team. The training and the capacity building is another issue. So, and that is not sometime training. So you would discourage your client to make, well, we make a big IP trade secret protection day, and then it's all done. No, it must be over a it must have a continuity. It must go over time. There must be a first training building, and if a new person is incorporated into the team, he must receive this training and capacity building to know it. And well, the training or the sensibility of that must be around all the company. Not only those who have access, but the whole company, they must know about the trade secret, because if it is something so vital, they must know if that goes sour, the company is toast. Monitoring and measurement, that's another issue. So it must be under continuity. It must be measured if after a certain time, after 6 months, it is working. So is everything still at it was planned in the beginning, or do we have some changes? And does these changes have been written down into the policies, etc. So this is an important issue. Often they go all in from the beginning, but then over time they forget about all this, and well, you have a problem. Third-party management, that is another issue. You have clients, right? You have suppliers. You have other parties you're dealing with. Though, and often there are deliveries which are made to you, so the people come into your offices. There are clients who are come to your offices for meetings or conferences or whatever it is, And then you need to have sometimes they get some access to, or some part-time or partial access to your trade secrets, and the non-disclosure agreements must be signed by them as well, so that you cannot have a leak on something which on top of it you cannot control. And the corrective actions and improvement, this is with regard to an audit you are doing. If then there is a leak, or if a problem has arisen, and a systemic problem may come out of it, then you have to make the corrective measures being in place, so that the trade secrets is severely protected. So that is what you should know about the trade secrets so far. If you're doing this, advising this to your client, and on top of it your client are doing this, probably he will never do everything of it, but he should be advised to do this, then, well, he is on the safe side. And that is what you want to assure your client, to be on the safe side. The more you know, the better. And this is a bonus session for that capacity building of yours, in order to advise your clients on trade secrets in Europe.